Good morning, everyone. In History of the United States Constitution, we're going to go over the Fifth, Sixth, and Eighth Amendments to the United States Constitution today. We're going to group these together. I think of these as the criminal procedural protections that the Bill of Rights protects. Now, that's not to suggest the Fourth Amendment isn't part of that, but in order to digest the material in sizable portions, I thought we should bifurcate the Fourth as a distinct procedural safeguard from tyrannical government to protect us from being free from unreasonable searches and seizures and what the ramifications of those violations would occur, which is the concept of the suppression of illegally obtained evidence. Now, we know on the federal level that the fruit of the poisonous tree or the exclusion rule has become greatly diminished by exceptions to that rule. The most significant one under a case called Herring, which basically almost has to require on the federal level that police acted in bad faith in violating the principles of the Fourth Amendment. On the state level, at least in the state of Massachusetts, there is no good faith exception. If law enforcement, even with good intentions, violated the Fourth Amendment or Article 14 of the Massachusetts Declaration of Rights, we know that evidence is going to be excluded from use against the defendant. That's a very controversial principle. I don't doubt that whatsoever. I believe that's our discussion board question. But now getting into the Fifth Amendment, it has some civil protections against government overreach, but it also has several criminal ones. And we start off with no person shall be held to answer for a capitalized or otherwise infamous crime unless on a presentment or indictment of a grand jury. Now, this is a federal. Remember, a Bill of Rights were applicable to the federal government only for the longest period of time. Most of them have been incorporated to be applicable to the states because of the 14th Amendment. Now, what does the grand jury require under federal law for federal cases is that if the crime is basically a felony or above, the infamous, it's been determined to be a felony or above, which usually means a year in state prison or beyond. Obviously federal, it's going to be federal prison. There has to be a grand jury process. It's a filter in order to which the government just can't, in its arbitrary and capricious nature, bring criminal charges against the defendant. The grand jury has to determine whether there's probable cause. It's a low threshold, but it's a threshold nonetheless. They can't bring garbage charges against a defendant unless they have some evidence to present to basically neutral citizens. And in most jurisdictions, they see 23 grand jurors and 12 have to agree that there's probable cause to issue the indictment. It's called an indictment. All it is a charge. It's usually done in secret. It's completely one-sided. It's only the prosecution or the government presenting the information. And because it's not adversarial in nature, it's fairly easy to get an indictment against a defendant. But you still have everyday citizens, arguably your peers, reviewing about whether or not the government has at least made a prima facie showing, meaning on its face, it seems probable that the defendant did the acts as alleged based upon the information presented. It's no proof of guilt. In fact, if you guys get into criminal law, I know some of you are because you either are working in law enforcement or wish to or want to become attorneys, prosecutors, defense, I don't know what, but you want to work in that realm. The presumption of innocence remains for you, and the jury will always be told by the judge that just because you've been charged doesn't mean anything. It's just you've been simply charged. I think most people, though, and I'm a defense attorney, even I think when someone's been charged, must be a glean of cause for that charge to be had. So I think it's a little bit of a dangerous process. But the grand jury is a filter. And occasionally a grand jury says, there's just nothing here. There's not enough for me to think there's a probability the defendant did the acts as alleged. They didn't meet the elements. And that's called a no bill. A true bill is an indictment. A no bill is they didn't find enough. Now, that doesn't mean double jeopardy attached. We'll get to that. And that's also in the Fifth Amendment. So we'll go on. So that's the grand jury. This is only applicable to federal. Do states have grand jury? Massachusetts does. So for felony prosecutions, if they want to bind the case over to the Superior Court, it has to be a felony, which in Mass, you don't have to worry about this definition, but it's got to be a year or more to state prison. You can have a 2.5 year sentence to the House of Correction. It's not a felony. It has to be a year or more to state prison. In order for the Superior Court to exercise jurisdiction, there either has to be an indictment through the grand jury process, or we have an alternative method in Massachusetts called the presentment, where the district attorney will do a probable cause hearing, and they have to convince a district court judge that there's probable cause to issue the complaint for the Superior Court. Then it's bound over. It's a bind over process. That's rarely done. I've been involved in a few of those. Most of the time it's through a grand jury. Again, it's secretive. That's what makes it controversial, because we don't know what the prosecution's actually presenting to the grand jury. And there's some belief that if the defendant is popular or a police officer or something like that, the grand jury often doesn't indict, and one wonders why, because it's a secretive environment. But there's some rationale by why we want this secret, is because witnesses will suddenly disappear or be threatened or killed. And if a defendant is well aware that charges are being potentially presented to a grand jury, evidence might be destroyed and or people silenced. And so there's a method behind it. And it cuts both ways. I think it's here to stay, although every so often it does become controversial news about the secret process. Shouldn't we have transparency in the law? Yeah, unless there's good cause to show why. And I think there's some arguments why the grand jury should continue to exist. I'm not crazy about it personally. But anyways, doesn't matter what I think. Then the next one that everyone likes to talk about is double jeopardy. Double jeopardy only applies to criminal actions. So let's assume I've been charged with bank robbery. I have a trial. The jury finds me not guilty of bank robbery, and all they find me guilty of is illegal possession of a handgun, and I get sentenced appropriately. And now the government finds new evidence later on, or they think they have a better prosecutor to bring against me, and so they try to charge me again for the same events under the same statute in the same jurisdiction. That's a violation of double jeopardy, because that's what the framers were upset about. Our early forefathers were upset because what were the British authorities doing to colonists that they were dissatisfied with? They try for a crime, the local community would find them not guilty because they were not guilty often, and then they say, well, just do it again. We'll just keep doing it. Talk about bringing the weight and resources of a tyrannical government against an individual can be crushing. Financially, spiritually, it can really tear you down. So we wanted to do away with that. Government basically gets one shot to prosecute you, and if you're found not guilty, you can't be tried again for the same offenses. Now, a lot of people say, well, what about OJ? OJ was found not guilty, and then we hear about there was another trial, and you got over $10 million in damages against him. That's a civil wrongful death claim. Double jeopardy only applies to criminal matters in the same jurisdiction. So you might be charged federally with a crime, be found not guilty, and then the state decides to bring state charges that stem out of the same facts and elements that occurred. That would not be double jeopardy because it's a different jurisdiction under a different authority. There's been a lot of movies, I think there's even a couple from the 1950s or 40s called Double Jeopardy, because in theory, if you're found not guilty of an offense, say my client is accused of killing his wife over an affair, jury comes back and finds the defendant not guilty, and the defendant goes out in front of the courthouse steps and says, yeah, turns out I did kill her. Too bad the government couldn't prove it, but she really had it coming. Can they try him again for murder? No. Double jeopardy would protect him. Now, people don't do that because now they could be sued civilly for wrongful death, potentially even perjury or misleading a government entity. There's all kinds of other charges that hadn't been tried in that case that might develop as a result of someone's confession to something under double jeopardy. Double jeopardy only comes into existence after a verdict. And I've actually had a few trials where there's a mistrial, like along the way, someone testifies inappropriately or evidence is allowed inappropriately or some crazy things happen and a judge has to declare a mistrial. The case technically is dismissed, and then all of a sudden new charges are applied. And I get time and time again, not just my case, but I have colleagues that have mistrials or hung juries where juries couldn't come to a conclusion unanimously. And that's not in the amendments, but we do in all criminal matters now today. There's case law now everywhere in the United States. All criminal matters must be a unanimous verdict. Let's assume that's a hung jury. That's a mistrial. The case is now dismissed, and then they can bring new charges against the defendant. They don't have to. The government has a lot of discretion whether they want to do it or not. But if they do, I get defendants time and time again, my colleagues do too, saying, hey, double jeopardy, man, double jeopardy, do a motion to dismiss. There wasn't a verdict. Double jeopardy only applies after jeopardy has attached, which is a verdict. So it doesn't come up all that much. And the government knows about it. They don't bring charges twice because they abide, hopefully, by the Constitution. And the next one that most people like about, taking the fifth. You can't be compelled in any criminal case. Civil cases, in theory, you can be compelled to testify unless you have some kind of privilege, like a marital privilege or a priest penitent, patient doctor. Those kinds of privileges may allow you to refuse to testify. But in criminal matters, you have a right to refuse to testify if there's a potential that the information that might be elicited could lead to criminal charges against you, even if it's not about the underlying case. Like, geez, they want to ask me about my husband beating me up. I'm not going to testify because If the information comes out, it'll be revealed that I was in the middle of a crack cocaine deal, something like that. The problem is the judge will say, well, what is your Fifth Amendment privilege? And if you reveal it, you're revealing the information. So we often have these special hearings, and I've done a lot of them in my career, where someone will try to take the Fifth Amendment and the court will ask me or another defense attorney in the room to speak with a witness to see if they have a viable Fifth Amendment privilege, and then report back to the court as an officer of the court whether they have the Fifth Amendment privilege or not. And all it is a test of whether or not the person could have information elicited that could incriminate them. And why did the framers want this? Because if the government can force you to testify, they'd often force confessions back in the colonial days, or they would coerce you into saying things that didn't necessarily amount to criminality, but it would lead you into a very, very precarious situation in terms of liability. And so you have a right to remain silent and not testify against yourself. And this is used all the time. And most people don't like it. And I have to admit, even former President Donald Trump, there's been other politicians. I think Bobby Kennedy, one of my heroes, actually used it one time in a hearing against racketeer labor practices, where someone said, I take the Fifth Amendment. He goes, oh, you're going to be like a little girl and sit behind the Fifth Amendment. Or this person's taking the Fifth Amendment for one reason or one reason, although we know they're guilty of a crime. It's not necessarily true. People invoke the Fifth Amendment because they don't want information to be construed as such to lead them to believe that they've been involved in some kind of criminal behavior. And the right is inherent, basically, not to state information that could lead to your own demise. And it's pretty well here to stay, I believe, the Fifth Amendment. In fact, it's so important to keep a free society because government, in its attempts to solve crime, have historically used tactics that lead to confessions and or incriminations that haven't been very valid. And there's a lot of evidence of that people often confess the things they don't do because of psychological problems, but often because of coercion. People will tell you whatever they want to hear just to get you to stop doing whatever it is that causes them a great deal of burden. Now, because of that right to remain silent and not incriminate yourself in any legal forum, they developed something called the Miranda rule. Miranda's this guy that got arrested in the 1960s, and he was he didn't sleep for several days. They had feed him, and they were really browbeating him. They were saying, hey, if you don't confess, we're going to give you 10 times the length of the sentence, or we'll promise you basically good treatment if you do. Eventually cracked and testified, and he tried to get his confession thrown out, saying it wasn't a voluntary confession. The Warren Court, which was considered one of the most liberal courts in terms of civil liberties involving the criminal procedure process, said that because people don't know they have a Fifth Amendment right to remain silent, it's so imperative that before police officers interrogate, meaning question a defendant while in custodial custody, if they just bump into someone on the street or knock on the door and say, can I talk to you? And you do, the Miranda rulings don't apply. It has to be in a custodial, and that's a question of fact, where you're free to leave or you're not free to leave. Was a reasonable person believing they couldn't leave under the circumstances? I had police officers argue one time a person was free to leave, even though there's 6 police officers, and 2 of them were holding long guns, M4 rifles, and they had flashlights on my defendant in a back alley, and they were talking to him, but he's free to leave, he's free to go. No, he was in custody. Just because you don't have handcuffs doesn't mean custody. Obviously, if you have handcuffs on, you're very likely to be in custody. It's a totality of the circumstance to determine whether you're in custody. And then if the police do want to ask questions about what happened, to protect the defendant's constitutional rights, they have to be read the Miranda warnings. And basically, it's the right to remain silent, the right to have counsel afforded to you during questioning and also during any court proceedings. And then if you can't afford, one will be appointed to you at no cost. And if you do say anything to the police during the time of questioning, those statements can and will be used against you in a court of law. The police don't have to read the verbatim. It's always a very good idea that they do, because they often leave out a key or an essential element. And then any confession or statement made by a defendant while in custody through questioning, it has to be custodial interrogation. Doesn't mean you have to be under bright lights or anything like that, but any question can be thrown out. Now, what if a police officer arrives at the scene of a crime and he sees some guy holding a knife, and he's standing over a woman who looks like she's just been stabbed to death, and the officer just is walking over, and the guy says, oh, I just snapped, I couldn't take it anymore, I just stabbed her so many times, I feel terrible, I killed her. Could that statement be used against the defendant? Generally, yes. Why? Because 1, the defendant wasn't in custody at that moment, and 2, it wasn't elicited through questioning. and this comes up all the time in my practice. I get clients, I always love those phone calls, especially on Friday night. Good news, Corman, my case should be dismissed. You need to file a motion to dismiss right away. Case is garbage now. And I'm like, why? Because they didn't read me my Miranda rights. And I'm like, well, did you state a confession somewhere? They said, no. And I said, well, the evidence that they're going to use against you isn't a statement by you for them, and it wasn't made during custody. So the Miranda warnings are irrelevant. The fact that they read you your rights or didn't read you your rights under Miranda didn't prejudice you in any way, shape, or form, and you made no statements they're going to use against you. People are baffled by that. People think if you're not read your rights, somehow a case gets dismissed. If you're not read your rights, statements you make to police after questioning would largely be suppressed because it violates the Miranda principle, which is not really violating Miranda, is violating the Fifth Amendment concepts because you weren't warned of them. Voluntariness is a big issue, comes up. And I always think about that sometimes when I had one where an officer said, if you don't admit that you were selling this heroin, we're going to not only arrest your wife, we're going to place those kids in DCF custody, and they're going to be put up for adoption within a few months. If you say that if you tell us in a written confession, this was all in a videotape, ironically, it says, we'll not arrest your wife and we won't have DCF remove your children. And so he signed a voluntary confession. This is right, a voluntary I read it, it's voluntary. And the officer even says, no, is this voluntary? Well, the guy says, yes. Is it voluntary? The court decided it was not voluntary. And so you have to determine in the totality of facts what is voluntary or not. A lot of people don't think the police can use trickery. Yes, they can. And that's one of the good things the police, good about morally, but police can use trickery, like, hey, I was just talking to your buddy in the next room and you said it was all on you. And all of a sudden the person goes, oh, no, this is after the warning's given. Oh, no, it wasn't on, and the person decides they want to talk and they voluntarily do talk and they pin it on the other guy, but information comes out to leads to their conviction. Trickery is allowed. Sometimes promises are even not determined to be invading into the voluntariness of a confession as long as it's of someone's own free will. So there's a lot of cases that go into this whole voluntariness test. It's hard to remain silent as a defendant. I always tell my clients, I'm down at the police station right now. The cops want to talk to me, and they seem like if I don't talk to them, I'm in a lot of trouble. So you're in a lot of trouble if you're at a police station. Just tell them you talk to me, and they said I would not take you as a client if you said anything. And if they want to talk to you, they have to talk to me first. Then when they call me up, I just say my client has nothing to say, and it ends there. But people often feel bad, especially if they haven't done anything wrong. They feel bad about taking the Fifth Amendment and remaining silent. They feel like they're somehow incriminating themselves. This is true at trial. Defendants do not have to testify on their behalf. They don't have to prove anything. They're presumed innocent, and it's the government's burden to prove beyond a reasonable doubt they committed the alleged acts that have been purported by the government. The challenge is, though, I think a lot of jurors think because the defendant sits there in court and never gets to the stand and says, I didn't do this thing, this didn't happen that way, and I wasn't involved. A lot of people say if the person didn't testify, they must be hiding something. I think that's a natural psychological conclusion we often draw. And if I have a client charged with some kind of moral crime, theft, I don't want to get into all the different kind of crime, but crimes that I think about, they really want to hear you get up there and deny it. I'm one of the criminal defense attorneys. I'm probably the exception. Most criminal defense attorneys never have your clients testify unless there's an absolute reason. I think there's almost always a reason. They didn't do it, and they should get up there and say they didn't do it. But the reason why we don't want them out to get on the stand when they get up there, a skilled prosecutor can often make them look very silly, very inconsistent, and very much look like a dishonest individual. That's the risk of not invoking your Fifth Amendment. You don't even tell the jury you're invoking your Fifth. That's another reason why the rule is so sanctimonious, sacrosanct. You can't even I now call the defendant to the stand to tell his or her story. You can't do that. Only the defense can call the defendant to the stand to testify. Prosecutor can cross-examine, certainly, but just the defendant sitting there silently is the presumption that they decided not to testify, and they don't have to make any explanation for it whatsoever. Of course, if the court grants immunity, specific immunity or general immunity, then the defendant has to testify. You will not be charged for anything you say for any crime that's submitted to you. If that ruling is made by the court, now you have no reason not to testify, and you can be held in contempt of court. You can be punished for failing to testify. There are other people that don't have the Fifth Amendment privilege that refuse to testify. It's a person I care about. It's my kid. I refuse to testify. You can be sanctioned for that because it's not a Fifth Amendment privilege. So that's if immunity is granted. And then this next one, which doesn't deal directly with criminal, but it overlaps, can't be deprived of life, liberty, or property without due process of law. There's two kinds of due process. Most people agree there's a procedural due process, meaning that the government has to provide a fundamentally fair procedural system before someone's property fines or confiscation or their life or liberty is taken away from them. You have to have fairness in the process. Then there's an argument, there's also something called substantive due process, that the laws themselves have to be fundamentally fair. They can't be arbitrary and capricious. Like DOMA, the Defense of Marriage Act, was deemed to be a fundamentally flawed law in terms of its substance and therefore deemed unconstitutional as violation of the substantive due process clause in the Fifth Amendment. And there's another one in the 14th. The Fifth Amendment applicable to federal, 14th Amendment applicable to state, but the same meaning, substantive and procedural due process. And then and no private property should be taken for public use without just compensation. This isn't a criminal defense class or criminal prosecution class by any means, but property is sometimes taken by the government. It has to be for a public purpose, and the property owners have to be justly compensated. Now, be careful about public purpose. There's a very big case called Kelo, 2005, still actively good law. Most people think it's outrageous. Many states have passed laws banning it on state eminent domain cases. That what it means for a public purpose, many people think like, well, the land's going to be taken to put in a highway or an airport or a hospital or a public school or a park. Most of us would agree those were all public purposes. But the Supreme Court said a public purpose also means public improvement for society. So private lands from me can be taken away and given to a private corporation like a casino for a parking lot if it's going to create jobs and increase the economic viability of a community and things like that. And that outrages most people. Of course, I'll be paid for my property, fair market value. But what if I don't want to sell it? It's got a lot of sentimental value. I want to live there. I want to stay there. It's been my family's home for 4 generations. Doesn't matter. As long as it serves some kind of public benefit, even if it's going to be transferred from one private entity, me, to another private entity, a corporation, and it never gets owned by a public entity other through transfer, the case is said, and it's a very unpopular case, that meets the burdens of the Fifth Amendment of the United States Constitution. Now, the Sixth Amendment. It starts off in all criminal prosecutions. The accused shall enjoy the right to a speedy and public trial. Now, speedy has actually been divided in federal statutes and some federal case law. Federal prosecutions must start their trials no more than 100 days after making an arrest. There's some leeway if the defendant isn't being incarcerated on bail conditions because we're concerned about people losing their liberty. And we're also concerned about what? If you're charged today and you don't get to trial for 3 years, witnesses disappear, evidence gets lost, mislaid, people lose their memory of the event that occurs, and justice delayed is justice denied is the theory. We have a similar statute on the state level, but priority is given to people that are held in an incarcerated status for that. Defendants sometimes waive their right to a speedy trial because they also have to prepare. And it's fundamentally fair that if they have to track down witnesses or have scientific tests done to DNA or other things like that, and if it's delayed, sometimes a defendant can waive it. This is the defendant's right. It's not the government right to a speedy trial or the victim's right to a speedy trial. Some people argue it should be as well. No, it's the defendant we're focusing on because we're worried about a tyrannical government that's taking away the liberty of the individual citizens. Public is that we used to have a thing in England, and they did it a little bit in the early colonial days, something called the Star Chamber, basically secret legal tribunals where people were punished and they were tortured to get confessions. And it was like vigilante law. And when you have closed hearings where the public can't view and participate, where the press can't see what's going on, maybe unfairness and arbitrariness is going on. So the ability of the trial to be public is not universal. Like sometimes there's minor children involved and they want to protect certain privacy. But for the most part, trials in the adult criminal session, even involving minors, is for the public to observe and witness. So speedy, that's public. A venue and sequestering, how do we protect the defendant about what if there's a lot of public newspaper articles and news stories about the case that's going on? Wouldn't the jury get tainted? Well, there's a mechanism to sequester both witnesses and juries during the process of it so they don't get tainted. keeping them in hotel rooms, keeping them off the internet. I don't know how you do that, but especially with cell phones, being able to use that modem of communication. But generally speaking, the public trial does create some dangers for the defendant and for witnesses because they parrot one another if they get to hear what the other witnesses say. So we try to sequester them. I know when I have a trial, I just had a motion hearing recently. There are 7 police officers involved and a couple of other lay witnesses, civilians, and they were all sequestered, meaning they weren't put in hotels. It was a one-day hearing, but they were put out in the hallway. They were told not to discuss the case, and when they were done testifying, not to come out and discuss, hey, this is what I just testified to. These are the questions that were asked of the prosecutor and defense attorney. Can't do it. They're sequestered in order to create fairness. Venue, you're supposed to be. It is in the right in the amendment that you're supposed to be tried in the place. The exact language of it is. District wherein the crime shall have been committed, in which district shall have been previously ascertained by law. So if I commit a misdemeanor in Gardner, I should be arraigned and arrested and tried in Gardner. And if there's no jury trials in Gardner, probably over in Fitchburg, where the nearest jury trial session is. Because what the framers were worried about was in the colonial days that a lot of colonial agitation that was occurring, they'd get charged with crimes. They would ship them out to English courts where the loyalists to the English crown would clearly find the defendants guilty. You should be tried in your community where the events occurred. And that's subject to change. It's called venue or neighborhood. The venue can be changed to be fair for the defendant. And so say like my client's allegedly committed an act that's like really, really heinous and shocking to the community. I'm not going to get a good jury that hasn't had a biased opinion or knowledge about the case ahead of time. I'm going to ask that the venue be changed out to Western Mass. And that can be done quite a bit. In fact, F. Lee Bailey, many of you probably heard the name before. Maybe he was involved in OJ, but he had a much more famous case. And he didn't necessarily win it on the merits. He won it on the appeal over venue, and that was the Boston Strangler case. He said the guy that was charged as a Boston Strangler shouldn't have been tried in Boston. The case was so infamous there. They should have moved it out to Western Mass, where there'd be more likely a jury that wasn't tainted by pretrial publicity. We know now, I don't know why it's in the book here other than this concept of the juries becoming rarer and rarer, but I'm glad the author does it because everyone thinks everyone goes to jury trial. Very few cases go to jury trial. In fact, I think the book says 97% of federal, I think it's similar in the state level, get resolved through plea bargaining. And it's a very controversial topic. It's constitutional. I don't know why it's in the book to talk about too much, but I've heard people want to run for district attorney or different offices of prosecutors, and they always say, there'll be no plea bargaining in my office. That office is going to get shut down pretty quick. The volume of cases that come through, plea bargaining is a way in which the risk of losing the case entirely for the government, as well as the risk of losing on the charges as brought for the defendant, are so great that we often try to come to a compromise to seek justice that's fundamentally fair for both sides. And in doing so, we weed out a lot of cases and we try to do an agreement. And the judge always reviews these plea bargains. I mean, they're fundamentally equitable and fair under the circumstances. And a defendant has to freely and voluntarily admit that they're guilty, and for no other reasons, not based upon any kind of promise or because of the plea. They're admitting it to it because it's true, and that's the only reason they're admitting to it. It does weed out a lot of bad cases. And plea bargaining is here to stay. It's just a matter of course. But we still need those rights for those who say, I just didn't do it and I can't admit to it. And I always tell my clients, if you didn't do it, I'm not going to do a plea with you because I have, as an officer of the court, if you didn't do it, we're having a trial. And it's just a question of a bench trial, which resolves a lot of other cases. The bench trial is a trial just in front of a judge, and it's the defendant's right to waive the jury trial in a criminal matter if they want. Civil matter, both the plaintiff and the defendant have to agree to waive the jury and have a judge. But in criminal, it's just the defendant. And every so often I'll get a judge, they'll say, I think this judge is fundamentally fair and is going to give you a good trial as any jury, and I know him or her pretty well, and it's going to be a much quicker process. And we don't want to risk losing that judge because of sentencing. I think he or she is fundamentally fair. And so the standards are the same for jury trials for a bench trial. Jury trial, juries determine fact. The judge instructs on the law. The bench trial, a judge determines not only what the law is, but is also the fact finder, and they determine whether or not the defendant is not innocent or guilty. Don't ever say that. Guilty or not guilty. They can say, I think the defendant did it, but I'm not convinced beyond a reasonable doubt. It's a very high standard. And then the impartial juror, somewhere along the line, and there were some writings back in the early colonial days when we adopted this constitutional amendment, that the jury was made up of our community members and therefore meaning our peers. When I think of peers, I think of people like me in terms of education and religion and culture and economics. You're not going to get a jury of your peers. What are you going to get a jury of? And all the Constitution requires is that it's impartial. It hasn't prejudged the case or have any bias for or against the defendant or the litigants and the witnesses involved in the case. And that's the process. It's a French term called voir dire, to speak the truth, to make sure basically it's an impartial jury. And that's one of the most important things an attorney does, and I try to do it as best I can to make sure the juries don't have any preconceived ideas or concerns about the nature of the charges or who the defendant is or their racial makeup or their sexual orientation, all that kind of stuff that I think might impugn a jury's bias. I try to seek out getting a fair trial. I can get as many jurors dismissed for cause as I can. Like, for example, if I do an OUI trial, operating under the influence of liquor, and there's some of the jurors are active members of SAD or MAD, Mothers Against Drunk Drivers, or Students Against Drunk Driving, or they lost a family member to a drunk driver or been injured in a drunk driving accident, or they themselves have been charged with a drunk driving charge, I'll often ask that they be excused for cause. They are illegitimately able to not serve on the jury, and the judge usually will throw them off. It sounds walk the plank. No, they'll excuse them for cause because they can't fairly sit on this juror. Then you're allowed a certain number of what's called preemptory challenges. Preemptory challenge is just that. It's like a wild card. You can't use it for things like race, color, creed, national origin. I'm going to choose that way all the time, in my opinion. But for cause, and that's why jury trial selection can take a long time in a very high stakes case, like someone who's going to do a lengthy sentence if they're found guilty. We want to be very careful that we have a very objective and fair trial jury. And unlike TV, you don't know a heck of a lot about these people. You get a sheet that the prosecutor does and the defense attorney. I know their name, I know their marital status, I know where they live, their level of education, whether they served on a jury before, I think if they have kids, and then whether or not they know anybody involved in the case or have any known biases. And most people who are on it, I think most people don't think they have any biases, so it has to be explored a little bit. So I'll ask things. I get to do what's called direct voir dire in Massachusetts now. So I'll not do it to individual jurors, but I'll do it to the jury pool, and I'll say, hey, any of you guys think the testimony of a law enforcement officer is more likely to be truthful than someone who's charged with a crime? You'd be surprised how many people raise their hand. They're out of there for cause because they're not coming in with an objective ground floor fairness level. They're already biased in favor of the police. That's just one example. There are millions of them. Sentencing factors, I'm not worried about that. To be informed of the nature of the cause of action. Seems like common sense, but in the colonial days, people were arrested and they weren't even told what they were being charged with. It was just being rounded up and harassed. So you have to be told with specificity what you're accused with. And then eventually, if it's not clear from that original charge, they have to give you something called a bill of particulars, a very clear who, what, when, and where is what you did wrong. They have to spell it out because otherwise, how can a defendant, what did I do? They did something wrong. Well, what did I do wrong? You stole something. When? From whom? What was it? Because otherwise, how would I be able to find witnesses to see if I was even in that location at the time, or if I have some ability to show, oh yeah, there's a video at that place, I can grab the video. All of those things are important to fundamental due process. That's in the Sixth Amendment as well, to be informed of the nature of the cause of action. And that's done at what we call an arraignment. I've watched way too many arraignments. They're very boring. There's where the defendant either says they're guilty or not guilty. It's called entering the plea. Some of you, if you want to get into this thing, will be surprised that, this is the first day defendant got arrested last night for OUI drinking. And they're in front of the judge, and the judge will say, how do you plead, guilty or not guilty? And sometimes the defendant will say, guilty, Your Honor. I feel terrible. It was a friend's wedding. Drank too much. I want to plead guilty. Judge will say, okay, I'll enter a not guilty plea for you, and we're going to continue this date for this day. Are you going to hire an attorney, or because of your indigency, you're poor, are you going to ask for the court to appoint one for you? And then the defendant goes, I just said guilty, judge. He goes, yeah, I know. We're going to continue it for the day. I'm going to enter a not guilty plea. Judges in the courts don't want you to necessarily plead guilty on the very first arraignment day. It's often the day after. It's very soon after an event happened. You may be overcharged. You may be under the pressure of some remorse about the things that you were involved in. And you should really have some ability to reflect on the nature of the charges against you before you enter into a guilty plea, because it has to be knowing and intelligent to plead guilty. So that's why oftentimes a judge won't accept a guilty plea on the very first day. And then later at a pretrial conference, the defendant can do a change of plea. And there's certain things that we can do sometimes when a person is other than that one incident of a relatively minor crime, we can often help preserve their criminal record for convictions with an alternative type of sentence. I'm not going to get into that because it's not in the Constitution. This is the big one, to be confronted with the witnesses against them. And this is where the whole rules of hearsay come in. So people come in and say, my daughter says that, Steve, touched her inappropriately. That can't come into evidence. We need that daughter. She might be 7, 10 years old, and people are outraged by that. And there are developments in the law where maybe they can testify through closed circuit television or in a different proceeding where all the parties are, but the defendant has a right to confront their accusers. And oftentimes people think they have a ton of evidence, but it's often through other parties. I have a case coming up, for example, where supposedly the police officers interviewed a bunch of people, said my client was driving a car, it was an accident, and they turned out to be under the intoxicating drugs, charged with OUI drugs. Turns out my client wasn't driving at all, but the actual driver of the car wanted to get out of trouble because she was on probation for the very similar offense. So she accused my client of driving. The car was like split in half. No one actually witnessed this, but the two people that supposedly witnessed it, who said my client were driving, were actually driving themselves, or one of them was driving, the other one's the boyfriend of that person. And so I need those people to come into court. The officer can't get up there and say, hey, I'm Officer so-and-so. I've been on the force for 30 years in the city of Worcester, and I know that Ms. Jones was driving the motor vehicle because Tommy Smith said so. That's hearsay. That's objection. You have a right to face Tommy Smith, because then I could say, Tommy, wasn't it dark out at 3 o'clock in the morning on January 30th? Tommy, isn't it true your girlfriend was actually driving and you lied to the police because you wanted to get her out of trouble? Whatever it is, you can cross-examine. And you know what movie's not that bad? I refused to watch it for almost 10 or 15 years after it first came out, but I since have watched it. It's really not that bad, but it really brings up this concept of being able to confront the witnesses against the accused. And that's... I was going to say Tommy Boy, but God, let's hope it's not. It's My Cousin Vinny, and Joe Pesci plays. It's obviously very, very silly and comedic and ridiculous. No one dresses up as Colonel Sanders for a trial as a defense attorney, but in him, as he grows during the process and he's cross-examining people about their ability to perceive, their ability to have a memory, maybe their motive to lie. That's why the Sixth Amendment exists, because through that adversarial process of being able to confront your accuser, sometimes things do fall apart. Not always. It's not like Perry Mason. Most of you don't even know who Perry Mason was, but it's like a TV show where the defense attorney got up near the end of the episode. He was always able to make a witness crack and admit that they were the ones that were actually guilty, or it was one of their loved ones that was guilty. That doesn't happen in real life for the most part, very rare. I think I had one case where it kind of happened, where somebody kind of fell apart and recanted everything. And I've had lots of jury trials. It doesn't happen very, but the point is, imagine being able to be convicted of a crime when the persons that said they saw, heard, or experienced you doing something weren't even there to say it, where you could ask them questions about their motive, their bias, their ability to perceive, and that Constitution preserves that in the Sixth Amendment. And what's almost as important is to have compulsory process to bring witnesses on your behalf. So you could be poor, you could be indigent, you could be locked up during the pendency of this, but you should have the power to subpoena in witnesses with the government's assistance so they testify either for your behalf or just around the elements that surround the circumstances to help give clarification for the jury. Sixth Amendment, very, very powerful. And then the big one that comes up under Gideon versus Wainwright. There's an author right here from Massachusetts that wrote the book Gideon's Trumpet, and basically under the federal law for a long time, the Sixth Amendment said you have a right to counsel if there was a risk of going to jail. Didn't apply to all the states because it was a Bill of Rights, and the Bill of Rights only applied to the federal government. Gideon versus Wainwright in the year was Gideon v. Wainwright. I know it's in the book here. There's a picture of him at Gideon's army. Clarence Gideon, I believe it was in the early 60s, 63. Gideon v. Wainwright, he, on his own, petitioned the Supreme Court and said, I should be afforded counsel because it's a fundamental right. Without an attorney, the prosecution has an attorney, the government has it, and most people charged with a crime are often disenfranchised people that are ignorant of the rules of law and certainly procedure. Even educated people are, unless they're educated in law. Very difficult. It's like playing a board game. I don't like board games, but my family does. And every so often they throw this new board game out there and there's all these complicated rules and they know the rules and I feel like an idiot. It's not that I'm an idiot. I just don't know the rules of the game. And that's the unfairness of not allowing defendants to be afforded the right to counsel, even if they can't afford it, even in state proceedings. And Gideon v. Wainwright made the Sixth Amendment applicable to the states. So now the rule is any case where you could potentially do jail time and you're poor, you can always hire your own. Let's say you can't afford one, the government has to appoint one. It doesn't have to be the greatest attorney. It just has to be competent counsel. You can ultimately have your case flipped, however, meaning turned over if you lose on the basis of ineffective assistance of counsel. So we like to train public defenders a lot to get them to know how to do at least yeoman service, a decent job, to make sure the defendant gets a fundamentally fair trial. And actually, Gideon, who was convicted in his original trial, had a second trial going on, had a local attorney, and there's a film on it. I don't know if I have it posted up here, but I'll try to get it up from the Constitutional Law Center with Earl Gideon really in the video, and so were all the attorneys that were involved in the case. And Henry Fonda made a movie called Gideon's Trumpet about it because it was such a big deal in the late 1960s. Even though it was a 63 case, it came to a lot of media attention throughout the 60s. It's about equal playing ground, and that's why sometimes people say, well, justice is inequitable because the rich get the better lawyers. And there's some truth to that. Let's face it, the better lawyers tend to cost more, and people who are rich get better lawyers. Not universally, but often. So the right to counsel, very, very important. To be pressing and questioning is good. Okay. Now the Eighth Amendment. We'll start off with excessive bail shall not be required. We didn't like the government basically taking away people's liberty until conviction. And so when you're charged with a crime, the government does have a right to request bail, but bail is the only about the incentive to which you have a right to return to court. It's been held constitutional that certain crimes can be denied bail entirely because of the severity of the crime and the likelihood of wanting to flee justice. So like first-degree murder, you could be held without bail. Certain other crimes can be held without bail. And if there's multiple offenses that occur after being arraigned on earlier ones, your right to bail could be revoked during a period of time. That's actually constitutional. But as a general principle, when the government arrests you and charged with a crime, you are presumed innocent, and therefore you should not be having to post money, excessive bail, unless you're a flight risk, unless you're unlikely to return to court. That is separate from a dangerousness hearing. So in Massachusetts, if they're not asking for a dangerousness hearing, the monetary amount of money that you should have to post, maybe nothing, but up to some X number of dollars, should be based upon the likelihood of your returning to court. So every so often you hear a prosecutor say, this person's really a danger in the community. We don't want him out there. Well, then they got to petition for a dangerousness hearing and meet that very difficult standard. That's a different question. Bail is just your likelihood to return to court. And I know if you're a victim of crime, say I caught the neighborhood teenage kid breaking into my shed and I saw him stealing my bicycle, it's going to make me sick to my stomach, right? I call the police. He gets caught, gets charged with larceny from a building. I think a pretty serious crime. Let's assume he doesn't have the biggest record in the world. Parents live here in town. He lives in here in town. All of his community ties are here in town. He's had a few other scrapes with the law, but he's always showed up to court when he's supposed to. What should bail be said at that case? Probably nothing, because he's likely to return to court to answer to those complaints. But I'll see him the next day out free in the street. Will it get me upset? Sure, because I'm the victim of the crime. But we don't set policy, we don't set constitutional principles based upon the rapid need to feel justice and vindictiveness. We need it based upon a conviction. So if I'm upset about the defendant walking the street, it should be after he has his day in court and a full trial or admission take place before a court of law. And if you ever get charged with a crime, you probably say, hey, Quam was right about it. It's not that. I know most people that are charged with crime probably do have some involvement, but there are many that aren't guilty. And we need to make sure that we don't, in casting that net, hunting for tuna, we don't catch too many dolphins. And how do we ensure that? Due process of law, and we go through the procedures before we take away someone's liberty. So no excessive bail or fines imposed, and then no cruel and unusual punishments. Now, that's a very difficult debate, and some people think the death penalty is cruel and abusive. I do, but I'm not the law. The law is determined by the court. The Supreme Court has told us largely that the death penalty, at least at this juncture, is not cruel and unusual. And certainly the framers didn't think it was unusual, because at the inception of the Eighth Amendment's adoption, the death penalty was given quite extensively. And so I know I don't have a constitutional ground to likely win that the death penalty is cruel and unusual punishment. But over time, there might be cases about who can it apply to. Should it be given to juveniles? Should it be people with low IQ? Should it be given to people that are accessories to a crime where they had no actual intent to do something very egregious. Should apply to any kind of, should larceny require death? So what would be applicable for the death penalty are what we debate about over those circumstances. But I think of some other punishments. Should sex offenders be castrated? Should should there be physical punishments brought onto people? Those are the kinds of questions that develop under the, should we tarred and feathered like we did in colonial days? So what is cruel and unusual is under different circumstances going to be debated throughout time. And every so often you'll hear about a punishment that's kind of wacky. Like you'll see somebody with a billboard walking up and down the street saying, I'm an idiot because I was texting while driving on the street, and they have to do it for 5 days over a course of a month or something like that to let everyone know they're an idiot as their punishment. And I always have occasionally a friend who goes, hey, isn't that unusual punishment? Shouldn't that be barred? Often how the courts get around that is saying, I'm going to sentence you to 6 months in jail, or if you agree, as an alternative, I'll allow you to do the following things, which would be quite unusual. But that's by agreement, so you can't claim it's an unusual punishment because you've accepted it. But I don't think the electric chair has been deemed unconstitutional. But what has been deemed unconstitutional, juveniles under the age of 18 can't get the death penalty right now because they just don't consider to have the mental wherewithal the same as people at an older age in terms of mental cognition of the nature of the acts that they're involved in. The debate goes on and on and on and on. And I'm not too concerned about that. I went really long, but I wanted to cover the Fifth, the Sixth, and the Eighth Amendments. The book does a great job, but there's a lot here to swallow, so I'm going to probably give a 2-week window on this assignment. Look on Blackboard, you'll see where it is.